Hi there, welcome to my study. Welcome to an episode about HMOs. This episode is going to deal with definitions of HMOs. So we're looking at the new Act, the HMO Northern Ireland Act 2016, which we know was enacted on April Fool's Day this year, showing that the department has an element of a sense of humour, albeit when to enact, not really in anything else. So unfortunately, this video it has been difficult to do. It's quite wordy, unfortunately, which means that you need to look at the legislation. So I've recorded it on the screen, and I'm going to sort of pass over to myself here to go through this on the screen. There are more videos to follow on HMOs. We're going to find out more about them over the coming episodes, and as just simply we continue within even the legal profession to continue to discuss them. So hopefully this is of interest. Please feel free to comment, to private message me if you have any queries, and I hope you enjoy what we have prepared for you. So let's get started. The main definition we're going to look at is obviously the definition of an HMO, and it's in section 1 of the HMO Northern Ireland Act 2016, the main new legislation enacted, as we know, on the 1st of April this year. The definition of an HMO is broken down into various 4 or 5 in fact constituent parts, and we're going to look at those parts separately because they all have their own sort of sub definitions, if you will. So a building or part of a building which we look at is an HMO if it is living accommodation, and again everything surrounded by an oval we will define separately. So it's living accommodation and it is occupied by 3 or more persons as their main or only residence, and those persons form more than 2 households, and rents or other consideration is to be provided by at least one of the occupiers. So far so good. Let's break that down. So the building or part of a building aspect. Schedule 1 of the Act provides some exceptions and omissions in terms of what building or part of a building actually means. It broadly repeats the existing categories in the old HMO regime, but it now includes reference to the owner living in the premises, which I think was one of the grounds originally for a judicial review of the HMO scheme several years ago. So if a property owner or a member of their household occupies the premises, it won't be treated as an HMO, which I think is important. If we look at section 2 then, the definition of living accommodation. Living accommodation is capable of being occupied as a separate dwelling or forms part of any building or group of buildings in single ownership, and its occupants share a toilet, personal washing facilities or facilities for the preparation of cooked food. Now I've put in single ownership in capitals there. It is defined in a way which prevents avoidance of the legislation by artificially dividing ownership of a property between, say, members of a family or connected companies. Also, and slightly weirdly, living accommodation is taken to include any yard, garage, outhouse or other area or structure capable of being occupied or enjoyed, together with the living accommodation solely or in common with others. I'm not entirely sure why this is in. I surmise that it is to ensure that all potential parts of a property which contains an HMO will have the same safety standards applied, but frankly, you know, it's, as far as I can see, it's open to the landlord or letting agent to define the premises to exclude these areas. So I'm not entirely sure why it's in there in the first place. I'm not really sure how that works out, but nevertheless, for the purpose of this, it is defined as living accommodation. Section 3, which I think is a really important one, deals with the main or only residence. So people count as occupants only if the accommodation is their only or main residence. And I think that this definition gives some welcome clarity. It gives certain cases in section 3 where people will be treated as living in a potential HMO as their only or main residence. So people count as occupants only if the accommodation is their only or main residence. Accommodation occupied by a student during term time is regarded as that person's only or main residence, which is certainly something which has been talked about for a long time. People staying in domestic violence refuges are also to be treated as occupying them as their only or main residence. I'm aware of some letting agents, they will have a tenancy agreement with charities who provide refuge to people at short notice, and they're going to have to be careful as to whether or not an HMO is created here. If you have 3 separate people living in one of these houses, then you do actually have an HMO. And finally, not a massively common thing I suspect in Northern Ireland, but seasonal workers living somewhere where the employer has stipulated as part of their seasonal employment are treated as occupying that place as their main or only residence. Section 4 specifies the meaning of household for the purpose of HMO licensing. So this includes members of the same family, and again, family then is sort of subdefined. So a family includes married, unmarried and same-sex couples and stepchildren as well as blood relatives. Additionally, a person who is a personal or domestic carer in a residential capacity is to be treated as a member of the household for the purpose of the Act. There is a power for the department to provide that other persons are treated as being in the same household as well, and I'll talk at the end just about the department's discretion really throughout the Act. Final thing then to look at is rent or other consideration. You must have a rent or other form of consideration for the property to be an HMO. So owner-occupied apartments won't accidentally fall into the regime again the way they did. One of the earlier slides I showed had that sort of photographs of Victorian houses. I'm sure we're all aware of the horror stories of the old sort of Victorian renovated houses which were converted into, say, 3 or 4 self-contained apartments occupied by the owners of the apartments, and at one stage it appeared that the housing executive had considered that these were HMOs under the old regime and were requiring the apartment owners to carry out very expensive works to bring them up to a completely arbitrary HMO standard. So that final definition of HMO, where you have to have a rent or other consideration, basically takes those poor owner-occupied apartments completely out of the equation. And do you know what? That is sort of it in a nutshell, certainly for this episode. We have a building or part of a building, we have living accommodation, we have main or only residence, we have a definition of household, and we've looked at that requirement for needing a rent or other consideration. All of those things have to be present for the property to be an HMO, but there is one thing which I think is actually really important. And in most of the preceding sections, there is a catch-all at the end of each section which gives the department power to issue regulations to amend or remove or add or otherwise tinker with the various definitions. This, I think, is a sure sign and a tacit admission that the department is aware that there was a laughably poor level of consultation. I don't think there was any widespread consultation with the legal profession, and yet as soon as we look at the legislation we can pick holes in it, we can see difficulties, some of which we will deal with in the next episode, and really the consultation was so poor. I think that the department knew that they were going to need the power to fix issues quickly by way of regulations rather than be judicially reviewed upon judicial review upon judicial review. So as I say, I think that's probably all we can take in for our sort of this instalment. In the next video I'm going to look at HMO notices and what to do if you get one. I'm going to look at the new standard conditions which accompany any successful license application, and I will ask whether they actually misrepresent the new law, and then I look at whether it is legally possible to buy an existing HMO and not breach the new law. So plenty of things to come. Thank you so much for joining me, and more to follow soon.